Generally, a contractual promise is binding only if the other party provided something of value, which is called consideration, in exchange for the promise. But what if the parties later want to change the contract? Do contractual modifications always require additional consideration? The Iowa Court of Appeals explored this question in Quigley v. Wilson. Lester Quigley Sr. entered into a contract to sell his farm to Donald and Janis Wilson for $210,000. Under the contract, the Wilsons were supposed to pay Quigley $7,000 per year plus interest until the farm was paid off. This arrangement worked for several years. However, the Wilsons assigned the contract to someone new. After the first year, instead of paying the Wilsons, the new person returned the farm to them. Without the expected income from the farm, the Wilsons were unable to make the yearly payment on their contract with Quigley. The Wilsons approached Quigley about this issue. Quigley was living in a nursing home at that time. He was concerned that if he took the farm back, he might face negative tax consequences. Further, the farm's value had decreased dramatically, to almost half its original sale value. After negotiations among the parties, Quigley's attorney drew up a new modified sale contract. This contract reduced the farm's price from $210,000 to its current market value of $120,500. The modified contract also reduced the yearly payments from $7,000 to a little over $1,500. 2 years later, Quigley created a conservatorship and put his 2 children in charge of his legal affairs. The children sued the Wilsons, arguing that the Wilsons had defaulted on the original sale contract. The Wilsons' defense was that they had made all the payments required by the modified contract. The children claimed that the contractual modifications weren't effective because the Wilsons hadn't provided any consideration to support the modifications. But for procedural reasons, the trial court wouldn't hear the children's consideration argument. A jury found that Quigley had been competent when the contract was modified. The judge ruled that the modifications hadn't been obtained through fraud or duress. The trial court entered judgment for the Wilsons. The children appealed to the Iowa Court of Appeals.